We're proud to announce CISO Stories, a new podcast series in partnership with Cybersecurity Collaborative and Cybereason. CISO Stories features the candid perspectives and experiences of frontline senior security executives and dives deep into timely security topics. CISO Stories is hosted by Todd Fitzgerald, VP of Cybersecurity Strategy at Cybersecurity Collaborative, and Sam Curry, Chief Product and Security Officer at Cybereason. Listen weekly as they speak with extraordinary CISOs by visiting securityweekly.com/CSP.
And welcome back to Security and Compliance Weekly. Hey, if you want to stay in the loop on all things Security Weekly, visit securityweekly.com/subscribe to subscribe on your favorite podcast catcher or on our YouTube channel, or you can sign up for our mailing list, or you can join our Discord server, or you can follow us on our newest live streaming platform, Twitch. There's a brand new platform in Bedrock, and it's called Twitch. Anyway, you have to be a Flintstones fan to get that. I'm old. Also, our next technical training will be on May 6th at 11 a.m. Eastern Time, and it will be exploring common misconfigurations of Nginx, the damage they could do, and how to avoid them. Also, next up, see how our attackers can gain access to endpoints and learn defensive strategies to protect against those attacks in our May 13th technical training, also at 11 a.m. Eastern Time. You can sign up for both of those by visiting securityweekly.com/webcast and register now. Also, of course, if you've missed any of our previously recorded webcasts or technical trainings, you can find them at securityweekly.com/on-demand. All right. Let's get back into this whole data privacy versus security discussion. I do want to make sure that we get to the who, what, where, and when, and why, and how part of the discussion, and focus, on what the ramifications are of the new Virginia law, in the opinion of our esteemed guest, Mr. Chris Penn. So, Chris, I guess is who. First question for GDPR, for CCPA, probably most people are somewhat familiar, but as far as the new Virginia law goes, who should be worrying about this?
So I won't talk about the exemptions because, quite frankly, the way they've been written today is not going to stay that way. It will be amended. Exemptions are going to flex. But currently, in order to be in scope for the Virginia law, it's any organization that processes data on at least 100,000 Virginia residents, or they process data on 25,000 Virginia residents, but more than 50% of their company revenue is generated by the sell or sharing of personal data. And there's no threshold as far as income goes or revenue goes on this. So if you make $10, right? If you're processing 25,000 residents' data and you make $10 a year, if $5 of that comes from that sharing of information, then you're subject to this law as it's written today.
Okay. Wait. So I've been predicting for years that we're going to see data laundering companies rise up because of GDPR and because of CCPA and now because of this. So your point about if you make $5 on the data collection, data dissemination, data processing, whatever, you're subject to this. Am I correct?
Absolutely.
Okay. So what if I don't make any money? That little firm over there that happens to have the exact same board of directors and happens to be owned by the same people, and I just gave them bushels of data to start them off. They make money. I just buy it. I buy a license to use the data or something like that. What do you think?
So that goes into, you would be dubbed as what the law calls a processor. You would be processing data on behalf of the organization that uses data to make money. So you'd have to have a binding contract between you and the organization you're selling to.
Well, I mean, I own both companies, so I can just sign. That's no problem. I've got a contract. We're good, man. It's cool.
No, it all comes down to liability and where that lies.
Right. Mm-hmm. Exactly. And that's where I'm going with this.
And you're small, so you can self-assess. You can self-attestate.
Until the Attorney General steps in, who's the enforcement body for these regulations, and says, nope, you've got to pay us $7,500 per person who's impacted by this.
But
wait. How is the transfer? Hold on. Time out. Let's back up here for a second. Josh, in your example, how is the transfer of data happening?
Well, let's assume the most innocuous possible way, that the small company, I'm smart and I set it up from day one. For example, I'll give you an example. And this is a totally legit example. Bowflex is the exercise equipment company, right? Except it's actually two companies. They have a lead generation company, which is the one you see with all the advertisements on the TV. And this is an old example. I don't know if this is still true. But they have a company that goes out and gets the leads and then sells them to Bowflex, the exercise equipment company. And that's so they each have different goals, but they're very focused on their particular goals. So let's assume that I decide to set up a company to do things with data, but I set up a second company at the exact same time. So the small company, the data company, let's say, they've been collecting data from day one, and I've been selling it to the other company. You know, the small company's been selling it to the larger company, or leasing it, or licensing it, or whatever. But the small company has the breach. Well, I mean, that's fine. I don't care. I'll set up another one.
Yeah, you're still.
That seems like, if I may, that really seems like you'd be able to pierce the corporate veil on that.
That's not piercing the corporate veil. That is going from company to company,
same owners,
not from company to person.
Same owners dealing with the same data being resold. So one, I'm sorry, that
you're
really
sort of
sounds.
Right.
We need, you know what we need to do? We need to save this question for Priya and ask Priya, what is the ability to pierce the corporate veil when somebody has two companies that they set up to exchange data between? One company is making money in one way, one company is making money in another way.
Well, what if they don't even have the same interlocking directorate boards or whatever? I mean, there's a lot of different variables here. But the point is, and Chris,
yeah,
I'm
but the
curious
executive director would be the same, because like you said it yourself in your example. Well, now hold on. You said it in your example. You would be the owner of both companies. So,
oh yeah, I'd said it in the example, but it doesn't have to be. For example, there's another one. There's a large chemical company that actually took all of its lawsuits and threw it off in a divergent company, and basically it said goodbye. Okay, I mean,
what if you were to throw a nonprofit in that mix? What if you were to throw a nonprofit in that mix?
I don't know. I mean, there's lots of variables, right? So, Chris, what do you think about the idea of, and I'm calling it data laundering. There's probably a better term, but, data obfuscation, data laundering. What do you think of that?
Well, data obfuscation, right? We'll talk about that later, but that's one of the safeguards. But data laundering or manipulating and selling data in manners trying to get around the laws, essentially. That's going to show up quickly. The first time an AG comes in, and because they get alerted to this type of activity, right, they're going to throw the book at you, because not only are you not following the law, right, you're taking measures to try to avoid the law. Think about tax evasion, right? If I create this shell for that shell for this other shell.
That Apple and all those large companies do really successfully. I'm not saying they evade
yes, and that other companies have tried when they've spun off other businesses to try to hide their activities.
So let me throw in a couple questions that came up in the Discord, and I think at least the second one in part ties into what was just being said. Maybe they both do. The first question is, and it's a little bit long, let me just read it. It seems to me most of the privacy laws are enacted to protect companies hoovering up consumers' personal data, which is understandable, but the vast majority of spending I see in the corporate world is trying to protect customer and employee data, which in my humble opinion, employees have an explicit agreement already for data collection usually, and customers are mostly corporate identity, not really individuals. Is that an overreaction?
So depending on the organization, it might be a company, right? That might be their customer. But if you think about a retailer, the Walmart, the Amazons, the Costco's of the world, right? Their customers, you and I. We walk in, we buy things, they track us from the moment we walk in the store. Think about a casino, right? They're not the only people that watch biometrics and thermals and all these other things. A lot of retailers are doing that these days too, especially with the pandemic, right? A lot of companies have now incorporated thermals into their stores. You didn't consent for that when you walked in. There was no signage stating that they're using this technology. And because of that, there's no purpose attached to it, right? Inside of the company, they know that, okay, we're going to use it because of COVID, right? We want to make sure that, it's proximity tracing or seeing who's
Contact
been
tracing,
impacted.
contact tracing, yeah.
Yeah, contract tracing. There you go. Seeing who's been impacted because you walked into the store and maybe you had a fever that day. So I think the law is twofold. One, it wants to ensure companies doing the right thing to ensure they're protecting the consumer side of the house. It's also setting bounds for everybody, that everyday Joe, to be able to say, I know what this company is supposed to be doing with my data, and you should have some sort of I don't want to say comfort, but some sort of level of expectation that the company is going to do just that. Prior to these laws being created, it was really the wild, wild west. You sign up for a Facebook account back in 2015. They can do whatever they want with that data. They can sell it to 50,000 different companies, right? A dollar a piece. They just got $50,000 for your Facebook account. That didn't cost you anything. And that's really what they're getting at. Now, what happens with the 50,000 companies they sold your data to, right? All those companies got to make their dollar back. So they sell it to 100 other companies, and it gets out of hand. You end up with the robocallers texting your phone. You end up with, you're getting all these marketing emails about, you signed up for Facebook. Now you're getting ads about Chinese food, right? There's nothing relative to it. I think Jeff talked about it earlier, right? You were speaking with somebody and all of a sudden advertisements or something started popping up. And that's really what they're looking to protect and avoid, is having those types of situations occur.
So you're saying to help coalesce a lot of that together, you're saying a good deal of this has to do with business ethics, right?
Ethics and purpose. Like, why did you collect my data in the first place? And the usage of my data should be limited to just that purpose. If you want to go above and beyond that, then you need to get my consent or my acceptance for that type of activity to happen.
So let me ask a very basic pointed question, is because I haven't read the law. I haven't read any of the laws, I don't think, that we're talking about. Is PCI, the nature of the law...
You just admitted you haven't read PCI.
PCI is not a law. Hello?
It's not a law. Try again.
It absolutely is a law to Jeff. Come on.
Yeah, but it's not a law on the books as in traditional law like CCPA or CDPA or GDPR.
If you don't shut up, I'm going to forget my question.
What?
I'm an old man. I already forgot. No,
stop shaking your cane at us.
Is the nature of the Virginia law? Let's stick to the law at hand. Designed to protect against data theft, data loss from these companies, and making sure that they're protecting it, or is it more focused on the responsible, appropriate, ethical, legal use of data by said companies?
So there are requirements in there that the company must, do its best. We all know that's not, it's not realistic to say a company shouldn't have a data breach, right? I mean, we can all say that, but in a legal term, you can't come out and say that you can't be breached, right? So there are requirements that, you have to provide X, Y, or Z type of control in order to best ensure, the security and handling of the data, to try your best to ensure there is no breach. But in the case that there is a breach, just like with PCI, there's a timeline you have to follow. You have to, alert people under, 30 days, 45 days. And you have to also have a plan, right? What's your response plan? What's your action plan? What are the next 12 steps you're taking because the breach happened? And then when you identified how the breach happened, how are you going to fix it, right? All this comes to question. So yeah, it's absolutely applicable if that's where you're going with it, Jeff.
Well, I was trying to ask a simple question that got too complicated. Is the law focused on, making sure companies protect the data in a secure manner, similar to something like PCI, which is make sure this data doesn't get stolen or try to prevent this data get stolen? Or to what degree is the law focused on actually trying to dictate the appropriate use of all this data that the company might be collecting, said company?
Yeah, so as deep as these privacy laws, and this goes across the board for GDPR, CCPA, and now CDPA, because these laws are written by legal folks, they don't know the difference necessarily. And I'm speaking generally here. I'm sure there's some people out there that do, but Generally speaking, your average lawyer is not going to understand the difference between obfuscation or pseudonymization or encryption or masking. You start hearing all these different terms thrown around. Even if I just say the word labeling, right? Even in your head, Jeff, you probably just went to 10 different things. Labeling could be this, 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 this. It all depends on who you're talking to. Right. So what you see in these laws is that appropriate safeguards must be used. And now that word appropriate is going to vary from organization to organization, because the objective of these laws isn't to have your company go out and purchase some new, multi-million-dollar security stack to protect the data. That's not where they're going with it. But if you're an organization, and because we're all familiar with it, if you're an organization that's leveraging PCI and you're meeting the DSS year after year, that means you must have things in place like FIM and DLP and monitoring, logging. All these types of things must be in place, right? You've got two-factor, you've got, secured network zones, you have all these things that are there. Why aren't you using those for your other data sets that aren't financial, right? Why aren't you using those for your marketing database? Why aren't you using those for your HR database? And that's where these laws are focused on. We've been so honed in and just looking at your credit card that we've forgotten about everything else that makes you a person.
Okay, so what I'm hearing you say is the law is primarily focused on data loss, data theft, protecting the data, without going so much into the details of what the company might be using the data for. I'm hearing you say there's an assumption that you're, as a company, going to be collecting some set of data from your customers, just protect it, and they're attempting to expand beyond things that are specifically cited, like your credit and debit card information, because that's already covered under PCI. Is that a fair conclusion?
Yeah, they want everything that could potentially identify a person or a household to be adequately protected, but also for organizations to be 100% transparent for their intended purpose for that data collection and data usage.
So to what degree is the law dictating that companies or as a strategy, I guess, for protecting the data, to what degree are they responsible for either protecting the data from being identified with a particular person or household, I think you had said early, versus just sort of the general collection of data? Is my question too vague? Maybe it is.
Possibly. But I think where you're going with that, right, is should a company protect everything or just what could be tied back to an individual, right? I think that's kind of where
I guess my question is a way to solve the problem just to anonymize the data. If the company collects all this data and focuses, like the Anthem example I used earlier, if they focus their efforts on separating all the data they collect from the actual names of their customers, so that the data, if it's compromised, can't be correlated back to individuals, are they done? Or are they sort of above and beyond or besides that? So there
was an MIT study done, and they looked into how do you de-identify, how do you properly de-identify somebody's data. Just removing the names isn't enough. Right. Removing addresses isn't enough. You would have to remove so much. And this is what the MIT study found. In order to truly anonymize somebody, you would have to remove so much data that the data that remains is not worth the cost of the storage to store it. So it's very unlikely that you could properly anonymize somebody and still get value from the data. Which poses the question why you
not
have
easy.
It. What's that, Josh?
Yeah, properly anonymizing data these days is god awfully unpleasant. You can leave things like a state or a zip code or something, but if you even have a birth date, you can get, I think it's 96% of the U.S. with a zip code and a birth date. So it's not easy.
And if I have a job title in a salary range, right, I can get within 75% of who it is. And depending on that title, right? If it's CEO and it gives me a salary range, I could probably get within 98% of who that person is.
You're almost sounding like it almost sounds like cryptanalysis. It's not the direct correlation between the data set and the name. It's all the associated data that together can sort of point you towards the solution, as it were.
Exactly. What I was saying
That's
earlier with
really
concatenation. Good. That's exactly what I was saying earlier with the concatenation piece. Here on SCW, we've said it before, and we're going to say it again. To your point that lawyers are the ones who are writing these policies, there are two ways to handle dealing with this type of thing. You can either do it through the courts, or you can do it through legislation. And we're now starting to see that a lot of this is being derived through the courts, where a lot of people don't understand the precedence of what's being set and how that really affects them via the legislation. Would you agree?
Absolutely. That's oftentimes the breakdown is, and that's where I have to help a lot of organizations out. Even on my customer calls, you pick a company, right? I'll be speaking with them, and whether I'm talking to the security person, which I oftentimes do, they don't understand the wording of the law, right? Or if a privacy person, a lawyer, an analyst calls me up, they understand the law, but then when I say things like obfuscation, it goes right over their head. They're like, well, I don't know. Does that meet the parameters? It absolutely does, and this is why. And so I have to get into showing them examples, right? Here's data on the A side, here's data on the B side. When we're done, it's going to look like this. And so it's almost like it doesn't matter who I'm talking to, you're in some sort of a training session, because there is that persistent gap between IT and legal. GDPR kind of set the precedence that gap needs to be overcome. And that's when people like myself started to exist, to fit in and help lawyers understand IT and help IT understand legal speak. And although, the lawyer may say encrypt everything, we all know that's not a good strategy for so many different reasons.
Well, why wouldn't it be? Because there are compliance regimes that say data at rest, or encrypted data at rest, encrypted data at transit. Why can't we encrypt all of the things?
Sure, but encrypt what data at rest? Encrypt what data in transit? Right? I'm not saying what.
Hold on.
Saying what you're saying is wrong.
The way the standard is written is that it's not prescriptive, it's not descriptive of what data needs to be encrypted. It just says data at rest, data in transit, encrypt both. Well, so is it really fair asking, well, what data do we encrypt? What data do we don't encrypt? Whereas if you get hit by ransomware, right? How do you make that distinction?
Well, it goes down to the sensitivity of the data, right? I think Jeff's trying to chime in?
Well, yeah, I'm trying to jump in because Scott is more or less citing PCI. And my initial comment is, yes, PCI says protect the data at rest and protect the data in flight, but those are two sub-requirements out of the whole mass of 400 some odd requirements. The point being that those are two important steps to take for where data is being processed, but there's so many other things that you have to do. I think the problem is, Scott, that because the masses don't really understand how encryption works and what are the limitations of encryption or obfuscation, to use the more generic term, they see it as a holy grail. It's a silver bullet. It's if we just encrypt the data, we're done because nobody can read it. It goes back to Bruce Schneier, and I'll throw him under the bus here in a loving sort of way. When he wrote his original book, Applied Cryptography, he more or less said, why is security such a big deal? Computer security, internet security, all you have to do is encrypt the data and you're done. And I remember reading that as an employee of a certain 3-letter agency and a certified cryptologist, thinking, wow, this guy doesn't know what he's talking about, because that's only one small piece of the problem. It continues to be one small piece of the problem, but I think especially, and I don't want to throw anybody under the bus, but companies that are touting encryption solutions, I think they're relying on people thinking, wow, if we just encrypt, we're done. It solves all our problems.
Yeah, but Jeff, I've got a major problem with that, because HIPAA is also under the prescription of in-flight and at-rest encryption. Even though it may not say verbatim in HIPAA, HHS has come out and said, yes, encryption in flight and yes, encryption at rest for all data is required. So it's not just PCI here.
But let me come back to you, though, and say in both of those cases, right, when you say data in a PCI lens, it's talking, payment card largely. When you say data in the HIPAA lens, it's talking about your healthcare data. That's not for clinical or research purposes, right? If it meets one of those two qualifications, then it's not HIPAA. It's something else. If it is clinical and research data, and I saw this actually at an insurance provider, it goes into a data lake. It's not protected, and it's used for science and analytics and judging next year's rates and all this kind of stuff. But it's not protected to the same means that your healthcare data is. Even though it is healthcare data, it wasn't used for that intended purpose.
Well, let me throw this out just for the benefit of our audience, because I don't want to assume that people understand what I'm getting at. I want to be very specific. There's data at rest. That means it's being stored in a hard drive somewhere in some sort of file or folder, or whether it's a spreadsheet or a database or a flat file. It's stored somewhere on a drive, virtual or otherwise. Data in flight, it's being transmitted over the network, over the internet, over some form of networking communications. But there's another place where that data exists, at least one other place, and that's in memory when it's being processed. And process could be the act of encrypting or decrypting the data, but it's happening in memory, it's happening on the stack, and there's been a plethora. There's another SAT word for, hopefully, some people today. There's been a plethora of PCI breaches that have been largely the bad guys figured out, hey, all the data's in memory. We don't have to steal it from the database because it's been encrypted. We don't have to try to intercept it in flight because it's encrypted. But if we can attack the memory and attack the stack, we can scrape it all out there because it's all there in plain text. So memory scraping malware, which was the heart of breaches like Home Depot and Target, several years ago, and has been happening ever since. They're going after the data that isn't specifically addressed, although you can argue that, in any of the PCI requirements or the HIPAA requirements. So all I'm trying to say is there's more places to find the data rather than being transmitted or it's being stored. It's when you're processing it or doing something with it at an application level, which generally means it's happening in memory. So I just wanted to make that distinction.
And I think there's a good reason why that hasn't been addressed through PCI and other means, right, Jeff? Why not encrypt the data in memory too, right? And I think the answer to that is simply, I don't believe there's a technology out there that can do that today and still allow the systems to process it.
There's homomorphic encryption, which actually does allow that, but it's still iffy to a certain extent.
Yeah.
Don't get me started on homomorphic encryption. That's a whole. We'll have a topical discussion on that someday. Okay. But I lost my point. Go ahead. Somebody else talk. Dang it.
We're talking on the Discord. Jim, for example, is bringing like real-time data shouldn't be encrypted because it can lead to delaying communications. And so it's not so much the safety and security. Sometimes it's about the money involved. I remember when I was dealing with a financial firm, a trading firm, they ran with no firewalls, no IDS, IPS, no nothing, simply because any delay, like they literally ripped out, I think it was 150 switches at one point because they were 4 nanoseconds slower than advertised and promised. And I said, I'm sorry, it's your call, it's fine, but why? And they said every nanosecond, no joke, every nanosecond is about $1 million every 3 minutes. I was
I had the same analytics, working with the retailer in the e-commerce department. Management looks at the milliseconds. What's the average millisecond for a consumer to get to the web page to have it load? How long did it take somebody to check out, right? When they clicked on shopping cart, how long did it take for that cart to show up? And if there was even a 2 or a 3 millisecond increase because some new security feature was enabled on the website, they would remove it. That's got to go. That's altering the shopping experience of my consumer, and it's costing me money.
Well, speaking of shopping experiences, and this is an analogy or an example that hopefully most people can relate to. When you go to a brick and mortar store, which we used to do in the old days, and we're starting to do again, and you go to the cashier, the checkout
brick
line.
Things you speak of.
Bricks. What are those? Nowadays, over the last couple of years, more than likely we have a chip card in the United States, and we're chip and signature. We're not chip and pin as Europe and Canada are, which is a whole other topic. But when you stick your card in, you're now waiting 5, 10, 15 seconds for the processing to go on. Sometimes it happens sooner rather than longer. But there's some sort of measurable, visible delay while all the cryptography is happening. Are we really pained by that based on, versus a few years ago when it was swipe the card and you got the transaction approved, the authorization, usually in less than a second. It was measured in milliseconds, microseconds, whatever the term is. Do any of us care as consumers that we're standing at the checkout line for a few seconds now versus it used to be a lot faster? And if you're old enough and can remember the old days when the clerk had to pick up the telephone and call a number, and if you're really old enough, talk to an operator and read all the transaction information to get the authorization versus typing it in on the keypad and getting sort of an automation response. I mean, these are the real tangible things that most people can see, not to disparage the nanosecond analogy that you were just using. But this is the stuff that people worry about that are that are the companies that are trying to do this stuff or not. I'm sorry, Scott, go ahead.
No. I prematurely thought that you were leading into a question. Bringing back the days of having to verify a signature might be a good idea. With the advent of PIN and chip and trying to speed things up, more oftentimes than not, it doesn't happen that way. You stick your card in, it says, okay, are you good? Do you want credit or debit? You hit credit and bang, you're done. There's no other type of authentication that goes into it. And the chip and PIN is supposed to be more secure than signing something, but there has to be an even better way of doing it than just sliding your card in. I could take Jeff, I could take your card, or Josh, I could take your card and slide it in as you.
Yeah, it's just to point this just a nitpick difference. It's not more secure. It's allegedly harder to commit fraud because you are hopefully applying things that make it less likely to clone the card so that somebody else is using a fake card, or you don't have all the inner workings that are in the chip in a cloned card.
Jeff,
it's not more secure. Yep.
Are you talking chip and pin or chip and signature or chip and signature?
Chip and pin.
Either.
Chip and pin is more secure because it's two-factor authentication.
No, you can hit credit and bypass the pin altogether.
Okay,
how is that more secure?
True, but that's not chip and pin.
Okay,
that's chip and signature.
That's chip and signature.
Pin, utilizing
chip and pin in the United States is more like how we use a debit card as a debit card. And I think what Scott's saying is, but you can use a debit card as a credit card and get the same net result.
And he's absolutely right. I'm saying that the specific technology, chip and pin versus chip and signature, are very different in the terms of security. That's all. Now,
we agree on that 110%.
Yeah, I figured.
It's just the bypassing of that methodology.
It's ridiculous, isn't it?
Is the problem.
Yeah, absolutely. It's totally ridiculous. But I want to point out there was a comedian that actually did a routine. He walked into stores and he would draw pictures in a little signature box instead of signing his name. He's and it worked every time. So he decided to go for broke. He went into, I don't know if it was a Best Buy or some technology store. And he said, that video wall right there with 9 huge monitors? They're like, yeah. He goes, can you buy that? And they did a little discussion and they found out, yeah, you can. It's $150,000. He goes, I'd like to buy one. And they're like, okay. And they set him up for it. And he wrote not authorized for the signature. And they went, no, you have to sign it. And he went, that's my signature. And they said, and eventually they basically declined him from buying it, but from purchasing it. But they don't really check those things. And to Scott's point, maybe checking a signature would be a great idea. I personally think having a second factor of authentication would be better. But
yeah, and that's what I was about. That's where I was going to head with this. In that, what you have, what you know, what you are, and trying to split out that multi-factor authentication like we do now. Sure, it may hinder the way that we log into certain systems, but we have to give up some hindrance to stay secure and stay ahead of, or break that quote unquote cyber kill chain from last week of attacks. I mean, gentlemen, am I wrong?
No, that's a fair point, Scott. You're right. And I think you're answering the question of why we have chip and signature in the U.S. because the card brands and all the major merchants determine that the public in the U.S. is too stupid to remember a second form factor.
Well, and then that begs the question, though. Is there an ulterior motive behind moving to that methodology? Right? We have Facebook collecting data on us now and using that as a way that they're making money through data brokerage and selling it off. Could that move have had an ulterior motive that we're just not realizing?
Possibly.
But silence.
Dimitri brought up an interesting point, scenario on you claim fraud, the bank goes to the merchant says here's the signature, bank says that's not the signature, merchant says we don't employ signature experts, bank loses the claim and ends up paying for the fraud, which basically
the insurance pays for the fraud.
Yeah, I mean, basically it's cheaper, which is what drives most everything, to just not bother and just whatever, just issue the refund, issue the payback, charge back, let the fraud happen. I know of one major retail customer that I had that it was a deep, dark secret, but I know it now, that they do not fight any disputes. So you could go in and, spend $1,000 and then claim, oh, I didn't make that purchase, and they would just make it go away without question. That's their policy, is to not fight it. Because it's just cheaper to just
that's sort of like having a really shitty product on Amazon, and when it breaks and somebody leaves you a really bad review, you say, oh, I'm going to pay you, I don't know, $30 to take that review away. Now I'm going to pay you $50 to come on, man. Can we be better at this?
Right. Well, anyway, Chris, you haven't said anything in a while and you're a guest.
I'm listening to you guys go down this PCI tangent. Brings back good memories.
I was going to say, is it good memories or flashbacks of sleepless nights?
Maybe a bit of both, but it's always comical, I will say.
Well, and you lived the PCI world a little bit, and it's my biggest frustration. One of my biggest frustrations with PCIs is how the game has become. How do we eliminate card data storage and transmission? Let's encrypt it. Let's tokenize it. Let's make it not be card data, because the rules say if it's card data, then we have to do all these different security requirements. But if it's not, then we don't have to. And the game has very much become what they call a scoping exercise of, how can we get away with having to go through this PCI stuff, because
even where
devalue the data.
Even where the thought process went earlier, right? It's like, well, we have these new privacy laws. Well, what if I do X? What if I set my company up this way? How do I get around it, right? That was the first thing that came to mind. It's the same thing with PCI. It's like, there's 50 new controls coming out next year. Okay, great. Well, how can I get out of them?
Right.
Let's not even think about how could I just do them, right? How they spend so much thought process and so much money on how to get around things. Oftentimes it's just cheaper just to do it.
Well, and that's literally what I used to tell so many of my customers that would, spend hours and hours agonizing on how to avoid the requirement or how to get around it in terms of a compensating control. And I'm like, it'd be cheaper if you just did what it said that you needed to do and stop trying to dance. And they're like, and some small percentage of the time they'd be like, oh, you have a point. Yeah, we probably should just do that. Often it was like, how long would it take to do it? It was a major effort to do whatever it was, but still cheaper in the long run.
Yeah, the other thing that comes up, and you see this with PCI when you're trying to scope the card data environment, but the other thing that comes up in these privacy laws is when you have to surface all of, like, someone comes in and says, okay, I want to know all the data you have on me, why you have it. You have to surface all the data you have, obviously. But what happens with that, the backup of the database or the backup of the file share? You have all these redundant and duplicated data sets that even if you're a DBA, maybe you don't pay attention to that. If you're InfoSec, you certainly don't pay attention to that, right? You're looking at your production systems and, how do you keep the business going? That's your primary focus. But these privacy laws, they don't care. They don't care what your production system is. They don't care what your QA system is. They care about is that data that could be re-identified or allocated back to an individual. And so it kind of blows the CDE apart, right? It brings everything into scope. If it's controlled or owned or could be accessed by your organization, you're responsible for every piece of data that's on it. And then if we think about things like tokenization in the PCI world, right? That was another kind of catch-all. Well, I'm gonna throw all my payment card information over to this other vendor. I'm going to shift the risk, if you will, right? It's not my problem. It's their problem. Here, I'll pay you for that. Right. Privacy doesn't care that session ID, that payment card ID that you get from the tokenized vendor, that's personal information, because you as an organization could re-identify that back to what that card number originally was, right? All it's going to take you is a phone call to that vendor you're paying, and they're going to tell you what that card number is. So because it's within your control to re-identify, it does not meet the de-identified specification for opting it out of the law, if you will. Just like with encryption doesn't opt you out of the law because you can always just decrypt it, right? Chances are if you encrypted it, you have the key or you have a way of obtaining the key, so you can always re-identify it. So really the only way to permanently de-identify something would be encrypting it and throwing away the key, destroying the key, whatever the case may be, or something like masking, right? Where you're taking a name and you're transferring it to a different name with no way of reverting it. So you take Jeff, you turn him into Mickey Mouse, right? It's a fictitious name. You take his address and
how do you find that out?
How do you find out what?
No, we turned him into Mickey Mouse.
Yep. Don't give Josh
do it
ideas.
by joining the Discord.
Yeah, just you can go to Discord and change his name. There you go.
Yep.
Pretty much. Hey, well, our time is running out, unfortunately, and as is usual, we could probably go on and on and on. Let me give you, Chris, the floor for any parting thoughts, and do feel free to very briefly share with us, because I'm curious. What is PKWARE doing these days that would help companies with this whole problem of meeting these burgeoning data security laws? So
there's two things at a high level that PKWARE is doing today. One is they call it Smart Crypt, and essentially it gives you the ability to share encrypted data from one company to the other by a secure means without having to leverage your traditional secure transfer mechanism, right? So if I encrypt data, say it's a file, and I email it over to you, Jeff, you could have this PKWARE reader, and if I've given your email address access to that key, then only you could open it and read it, right? You would now have access to the encryption key, and I didn't have to have a secure means. I didn't have to have a key transfer or anything like that with you. So that's one way of ensuring your data is always protected, no matter where it's going. The other thing that PKWARE does is very interesting, and it's data discovery. So think about any type of data out there. It could be an identifier. It could be a customer ID, an employee ID. It could be any type of color, right? Just pick any type of data, anything your organization may be interested in. PKWARE can discover it across a wide array, almost every platform out there, structured, unstructured, semi-structured. A very good use case for this type of technology is as a assessor, as a PCI assessor, you come in and you say, okay, you told me your CDE is this little bubble. Well, how do I know, right? How do I know you're not storing credit cards outside of that? With technology like PKWARE doing its discovery on every other platform, it can come back to you very quickly and say in a report that, okay, here's the location I found payment cards, and I didn't find them anywhere else. So that would just give you as the assessor, right, assurance that your client's not telling you a fib. So that's kind of where PKWARE fits in. And in the light of privacy, as we've talked about, privacy could be associated with just about any piece of data out there. So organizations really need to boil down what is important to them, what is associable back to their client base, whether that be a company or a legitimate consumer. What elements do they have that can be associated? And once you have that thought process, you configure PKWARE to go look for those types of elements and surface it back into a meaningful report to take action on it, whether it's encryption, redaction, masking, or just awareness. Right. So all of it comes up.
So safe to assume that it would find credit, debit card information, primary account number?
Absolutely. CVV, account number, the whole nine.
Cool. I'll keep that in mind for my customers that are trying to carve out their CDE, their card data environment, and then prove that that's the only place where there's card data. The upshot of that exercise, I will add as a closing thought. The good news is, even though companies made it a game and like, woohoo, we can do away with PCI if we just shrink down our CDE. The upshot is they cleaned up a lot of data that was in a lot of different places throughout their organization where it wasn't being encrypted. People didn't even know it was there, and it was just ripe for the stealing. So, maybe the wrong motive, but a right result in terms of just sort of reducing the footprint of how much data was throughout their network. So, I
would say another thing you can add on there, Jeff, is as you're talking to your various clients and other guest speakers and everything else too, is when inevitably you're going to come into it and someone's going to ask you, well, Jeff, what did you see this other customer doing for GDPR or for this or for that? Right. And now what you can take away and tell them is you have all these controls for PCI because it's been mandated for years. You've been leveraging them for years. Why not just expand the scope, right? Your company's scope. Don't focus on payment cards anymore. Focus on payment cards plus all the consumer stuff. And then based on their sensitivity and their own threshold, right, determine what control is appropriate for the type of data at hand, right? Maybe you encrypt credit cards because you need to be able to decrypt them to process them. Maybe you mask email addresses, right? If you're not doing marketing and you're not doing email newsletters, that kind of stuff, maybe you mask it. Maybe you don't have a need to actually email it, right? And so these are all thought processes that people can go through.
Cool. We could keep talking PCI because I love to do that, but we won't. Chris, thanks so much for joining us today and helping to facilitate this hopefully interesting discussion on data privacy issues and challenges and goals and dreams. Would really like to consider having you back at some point when we have our co-host on that's a lawyer, which might sound kind of intimidating to you. So maybe we need to find somebody else to interview that's ready to go on the legal aspect.
I'm more than happy to hop on.
All right. Well, we may take you up on that. That's going to wrap us for us today for Security and Compliance Weekly. Stay secure, stay safe, stay compliant. Keep building those bridges and tearing down the silos. Until next time, we're out.